Good evening, everyone, and thank you all for joining us today as we discuss this important topic. My name is Shannon Shumpert, and I'm the Vice Provost for Institutional Equity, and I joined Hopkins just this past July, so I'm fairly new to this group, but happy to meet you all and happy to be here. Today, I'll be moderating our session, and I'm joined on the panel by Joy Gaslovic, who is our Assistant Vice Provost and Title IX Coordinator, and Linda Boyd, our Deputy Title IX Coordinator, and also Jen Calhoun, our Senior Advisor to the Vice Provost for Student Affairs. Our focus today is on the newly revised University Policy on Sexual Misconduct, which was revised in August to comply with the new Title IX regs promulgated by the Department of Education in May. This team, along with legal counsel, poured through several hundreds of pages of text in order to understand and make the necessary changes to our policies. So we're very happy to present these changes today and identify for you the components that changed, and more importantly, the things that will stay the same. We'll present these changes today, and also I encourage you to visit our website, sexualmisconduct.jhu.edu, for additional FAQs and other info on the revised regulations. We invite your questions today, and I believe that there is a Q&A module on your site, and we'll try to take this evening as many questions as possible. But if you do want to follow up with any of us directly, please feel free to either call our office or utilize email and reach out to us at oie@jhu.edu. And I think now I'll turn it over to Joy, and Joy's going to kick off our presentation.
Wonderful. Thanks so much, Shannon. And I hope everyone can see the screen. So I know we're going to do more of a deep dive into the sexual misconduct policy and procedures and the handling of sexual misconduct, and specifically the handling of sexual misconduct post Department of Education regulations in this training. However, we like to start out by reminding the community of all that OIE does. So we serve the entire community, all 9 divisions throughout Hopkins, students, faculty, and staff. We assess and investigate reports of discrimination and harassment and reports of sexual misconduct. We serve as a central resource for religious accommodations and disability services. We also provide harassment prevention, discrimination, Title IX, and disability services training. We also, as our team has grown and doubled in size in the past few years, we think a lot in OIE about what people who come to us can expect. And so we like to start out our presentations by letting everyone know that when you come to OIE with a report or just to ask questions, you will be heard, respected, treated fairly, informed of policies, procedures, and resources. And with every report that comes to us, OIE takes appropriate action geared to stop, prevent, and address problematic conduct. So let's talk a little bit more about these new Title IX regulations and what they have, what has resulted, what changes have resulted to our sexual misconduct policy and procedure, and as Shannon said, what stayed the same. So as everyone on this call may know, Title IX is a federal law that prohibits sex discrimination in university programs and activities. University programs and activities and discrimination on the basis of sex is prohibited in pretty much everything Hopkins does. So all of our programs, everything we do at Hopkins is pretty much a program or activity. So employment, student activities, and academic experience, alumni experiences, everything like that. Everything we do within the university is generally a program or experience. Everything we host, even programs that we put on that are not on campus. So in May of this year, the Department of Education released new Title IX. So everything we do is covered by Title IX, and sex discrimination is prohibited in all of our programs and activities. In May of this year, the U.S. Department of Education released new regulations that govern how universities must handle Title IX sexual harassment that comes up within programs and activities. And so we have gone through a process throughout the summer and comply with the regulations. So as of August 14th, we have a newly revised policy and procedures that complies with the regulations and that sets forth a new way that conduct that is defined as Title IX sexual harassment and that meets the jurisdictional requirements, so that occurs in the context that's required by the regulations, will be handled. And so that's what we'll talk to you about today a lot more. So what we like to start out with, though, is talking about what will not change, what will stay the same. And, we like to assure everyone that regardless, the regulations have not stopped how we handle, the fact that we will handle all sexual misconduct previously prohibited under policy, we will still handle it under university policy. Prevention, support, and proper report handling efforts will continue. We will still continue to use the preponderance of the evidence standard. We will still engage in supportive services and measures. Individuals who participate in any OIE action will still be entitled to supporters of their choice. The Sexual Violence Advisory Committee, which I am lucky enough to co-chair, which is an advisory committee to the provost that makes recommendations on prevention, support, and accountability efforts, will still continue its robust efforts to make recommendations to the provost on prevention, support, and accountability, and how to expand those things at Hopkins. Training requirements and opportunities for our community members will still continue, and we will still expand upon those. And responsible employee duties, which I'll talk more about later, will still continue. So as I said before, the new regulations have required us to handle what is now defined by the regulations as Title IX sexual harassment that occurs in certain contexts that Linda Boyd will talk more about in a few minutes. We are now required to handle that under a certain set of procedures, and the regulations really set forth what we need to do and the procedures that we need to have for those types of sexual harassment that meet the jurisdictional requirements. So this slide depicts how the procedures for handling different types of sexual misconduct will branch. The beginning steps of when we receive a report, OIE receives reports in a lot of different ways. We receive reports directly. We receive reports from our websites through the website forms. We received complaints by email through our various email addresses that we'll have up at the end. And we receive reports by phone. We also receive a lot of responsible employee reports. When we receive a report, we always engage in an assessment of that report to figure out next steps. We always look at, whether we always reach out to the individual impacted directly and start a conversation where we look at risks and anything we can do to make individuals who come to us feel safe, secure, and supported while we look into things. What has changed and what has been required per the new Title IX regulations is that we now add a third step in our assessment. We do a Title IX sexual harassment assessment. So we now look at whether the conduct meets the new definition of Title IX sexual harassment that's set out by the regulations. And we look at whether it meets the jurisdictional requirements. And if so, it needs to be handled under the procedures for Title IX sexual harassment. If it does not, it's still sexual misconduct that's prohibited under policy. It's absolutely still handled under the sexual misconduct policy. It's just handled under the procedures for other sexual misconduct, which, as Linda will explain, are very much similar, nearly identical to the way that sexual misconduct has been handled under our policies for years. So I'll turn it over to Linda now, who will explain and expand on what Title IX sexual harassment is and what these jurisdictional requirements are.
I'm muted. All right.
I'm muted too. Before we turn it over, I just want to remind the viewers that you can submit questions throughout the presentation, or you can wait until a natural pause, but it's totally up to you. Thank you. Please proceed, Linda.
Thank you. So looking at this slide right here, The blue represents all of the sexual misconduct that's prohibited by the university's sexual misconduct and procedures, sexual misconduct policy and procedures. And the yellow circle represents the subset of that sexual misconduct that falls under the definition of Title IX sexual harassment as defined by the regulations. So I'm going to talk a little bit about what is in that yellow circle. Quid pro quo sexual harassment is a specific form of sexual harassment when a person in a position of power makes a sexual advance or demands sexual favors to a person in a position of less power, and either offers some benefit to that person in exchange for sexual favors or threatens a negative consequence to that person. Under Title IX sexual harassment, quid pro quo needs to be committed by an employee. We recognize, however, that quid pro quo sexual harassment can happen by somebody who is not an employee but still has a position in power. So if there's quid pro quo sexual harassment allegations and the respondent is an employee, it would fall under Title IX. So it would fall under the definition of Title IX sexual harassment. And if it's someone other than an employee, it would fall under our broader sexual misconduct policy. Hostile environment is another form of sexual harassment. And the new regulations took the traditional definition of hostile environment sexual harassment and raised the standard, raised the bar for how somebody could allege that conduct. So in order to allege Title IX hostile environment sexual harassment, it would have to be conduct that is sexual in nature and is severe and pervasive and objectively offensive. That's a high standard that comes from case law. However, if there were allegations of unwelcome sexual conduct that did not meet that high threshold, but met the more traditional understanding of sexual harassment, which is severe or pervasive, then that would still be handled under our sexual misconduct policy. It just would not be considered Title IX sexual harassment. And finally, the VAWA offenses come from the Violence Against Women's Act, and that includes stalking, sexual assault, dating violence, and domestic violence. If we receive allegations of those types of conduct and they meet the other criteria that I'm going to talk to you about on the next slide, then those would be considered Title IX sexual harassment.
Linda, before we proceed, Joy, go back please to the last slide. Can you just give us some examples, just in case the audience isn't familiar with what would fall into each of these categories? Can you give us an example of each one?
Sure. A sort of classic example of quid pro quo sexual harassment involving students could be a professor demanding sexual favors from a student in his or her class related in exchange for a grade or some other privilege in the class. So that would fall under Title IX sexual harassment because a professor would be an employee of the university. Hostile environment. Sexual harassment could involve unwelcome conduct, unwelcome sexual advances, unwelcome comments, unwelcome jokes. But again, under the definition of Title IX sexual harassment, the behavior would have to be severe and pervasive and objectively offensive, which is quite a high standard. The conduct would have to be really quite bad. However, under our policy, under our sexual misconduct policy and procedure, we have defined non-Title IX sexual harassment, and that sexual harassment, unwelcome sexual conduct that is still severe or pervasive and impacts a person's environment, but doesn't have to meet that high Title IX threshold. So a lot of these assessments are going to be fact-specific to determine what set of procedures we use. And then for the VAWA offenses, sexual assault typically involves unwelcome sexual conduct, sexual conduct that's engaged in without consent. Our definition also includes incest and statutory rape. Relationship violence includes dating violence and domestic violence, so physical or sexual assault or the threat thereof. And it's because it's relationship violence, it is defined by the relationship between the parties. So we're looking at whether people have had a present or former dating relationship, whether they have been married, whether they have a child in common, things of that nature to determine if it would fit under relationship violence. It does not have to be sexual in nature to be considered dating violence or domestic violence.
Thank you.
Stalking is the final VAWA offense, and that is a course of conduct directed at a person that could cause a person to experience substantial distress, substantial emotional distress, or fear for their safety or safety of other people. So a lot of times the complaints that we get of stalking can involve a mix of somebody feeling like they're being followed or monitored, feeling like they're getting repeated, unwelcome, unwanted communications, whether directly or over social media. And that repeated conduct directed at them causes them to be fearful for their safety or to be extremely distressed.
Thank you, Linda.
Okay. So now, if we have conduct, an allegation of conduct that falls in that yellow circle, that falls under the definition of Title IX sexual harassment, we still need to know a couple of additional factors to determine what procedures we're going to be using and whether we'll be using the new Title IX sexual harassment procedures. The first, and probably the most clear-cut, is when the alleged conduct is said to have occurred. The sexual misconduct policy and procedures and the regulations that led to their revision went into effect August 14th, 2020. So conduct that is alleged to have occurred before that date falls under our former sexual misconduct policy and procedures. So it will not fall under the new Title IX regulations or the procedures that resulted from them. Title IX also specifies that it does not apply to conduct that occurred outside of the United States. So if we were to have an allegation of Title IX sexual harassment, for an example, a situation of sexual assault or stalking that occurred in a study abroad program, that would not fall under Title IX. However, it would still be covered under our sexual misconduct policy and procedures and would still be investigated, handled, and addressed based on the report that comes in and the preferences of the parties. In addition, Title IX specifies that in order to fall under the Title IX regulations, the conduct has to have occurred in connection with the university education program or activity. And as Joy mentioned earlier, many things fall under Hopkins University, Hopkins education programs or activities. However, we do at OIE receive reports of conduct that occurred off campus and unrelated to university education programs or activities. If we receive a report of that nature, it would not fall under Title IX. However, it could still be addressed under our sexual misconduct policy and procedures. It would just go through a different path. And finally, one significant change that came through the Title IX regulations is that in order for us to move forward with the Title IX grievance process, which I'm going to talk to you about on the next slide, we need to have a formal complaint. And a formal complaint is a signed, written document that is typically filed by the complainant, the person who experienced the sexual misconduct, and it is alleging Title IX sexual harassment, so something in that yellow circle, and it's requesting that the university investigate. So if we don't have a formal complaint, then typically we would not be able to start the Title IX grievance process. However, in situations where Joy, as the Title IX coordinator, does an assessment of information we've received and determines that there's a serious threat to the university community that OIE really needs to look into, she does have the ability to sign a formal complaint herself and commence the Title IX grievance process on that basis. So that would probably be a very rare circumstance. And short of that situation, we would need a signed formal complaint from the complainant. And one more fact about the formal complaint is that the person who files it needs to be someone who is participating in or trying to participate in a university program or activity. So for a student who has graduated, for example, and has moved on from the university, but then decides that they would like to file a complaint about someone who's still a member of the university, even if they filed a formal complaint, it would not fall under Title IX because they are not someone who's participating in or trying to participate in a university program or activity. Nevertheless, that report could still be processed and go through an investigation and other appropriate processes through our sexual misconduct policy and procedures, even though it doesn't fall under the Title IX regulations. We have the next slide, please. Thank you. So now I want to talk a little bit about the Title IX grievance process. When we have a situation where all of the criteria that I just described are met, so we have a formal complaint alleging Title IX sexual harassment, and it meets all the other criteria of being in the US and occurring in an education program or activity, then we are going to first issue a notice of allegations to both parties. And that is a written document that's going to describe to both parties that OIE is aware of the allegations. It gives them information about what's being alleged and the policy that applies. And it also describes their rights and it gives them information about next steps. From there are really two different paths that the formal complaint could go through. So one is an informal resolution. And that is a case where the parties voluntarily agree that they would like to resolve the formal complaint without going through the full investigation and hearing process. This is something where we very much ensure that the parties want to do this. There's no pressure for them to agree to something that they don't want to agree to. And if someone decides that they're interested in an informal resolution and then decides, actually they change their mind, they don't want to do that, that's completely fine. If the parties do reach an informal resolution, that's documented in writing and OIE would close the matter. So that is one path that a formal complaint could go on. If the complaint doesn't informally resolve, then the next step would be for it to go to investigation. An important thing to note though is that even if a complaint goes to investigation and begins that process, that doesn't prevent the parties from informally resolving it if they choose to do so and agree to do so. So informal resolution can happen at a later point in the process as well. If we do go to investigation, that is something that looks very, very similar under the Title IX procedures as it did to under our existing policy and procedures. So basically OIE would assign an investigator and that person would speak to both parties to gather information. They would speak to witnesses, they would gather relevant documentation and other evidence, and they would use that information to look into the allegations that have been shared with both parties in that notice. A step that's a little bit different in the Title IX procedures is that there is a built-in 10-day time period during which both parties get to review the evidence that OIE has gathered during the investigation. So that's a little different under our former policy. The parties would see the evidence through the investigation process when it's shared with them through the investigator, but now they have this designated period where they get to review it. After that review and comment of the evidence file, then the parties get to, then OIE will write an investigative report. And then just like our former process, the parties will get to review an investigative report, and comment on the investigative report. Now, the next step is where things start to look a little different. OIE, upon giving the parties the report to review, OIE will send its report and its evidence file to a determination panel or resolution panel of 3 people. Much like the resolution panels we've had in our existing policy for years, the resolution panel will consist of 2 university staff members or faculty members and 1 external legal professional, all of whom have been trained to do this exact kind of work. And any comments that the parties have submitted to the report will go to the determination panel as well. Unlike our existing process, the panel will now have the task of having a live hearing. And in our past process, a hearing was a possibility, something that could happen, but it wasn't something that the panel was required to do. Now, going forward, there will be a required live hearing if things move through this process and don't informally resolve. So we know that the hearing has been something that has caused people some concern about the changes to the process. So I want to talk a little bit about that. Each party during the hearing is required to have a hearing advisor. And the hearing advisor can be someone they choose, or if they don't have somebody that they'd like to bring, the university will provide a hearing advisor free of charge. The hearing advisor's role is to ask questions of the other parties and witnesses. So the parties themselves do not ask questions of each other or witnesses. It's all done through the hearing advisor. The determination panel listens to every single question that's proposed to a party or witness, and they determine whether that question is relevant. If they decide that the question is not relevant, then it doesn't need to be answered. So that's one of the ways where the hearing panel and the chair of that panel, who will be the legal professional, keeps control of the hearing. And in addition, we are developing rules of decorum to ensure that the hearing process will be respectful and professional. We recognize that people have concerns about being in this more adversarial environment, and one of the things that we've also been able to do through regulations is even after we're no longer in the COVID environment where most things are virtual, we will still be able to keep these hearings virtual, or to make it so that the parties are not in the same place when the hearing is happening. The hearing has to be live, but the people do not have to be in the same room. So we wanted to make sure that was shared as well. After the hearing, the determination panel looks at the evidence that was gathered in the hearing, the investigative report, the evidence file, parties' comments that were submitted, and they will write a determination of outcome that describes what they found, the process that they used to get there, whether they believe there was a policy violation, and if so, what the sanctions would be. There are then limited appeal rights based on certain situations that could arise. For example, the parties may have a right to appeal if there was a significant procedural error that could have impacted the outcome, or if there's an allegation of bias by somebody involved in the process that could have impacted the outcome. For student matters, the appeals go to the Vice Provost for Student Affairs. And I think that's basically the end of the process that would happen through the Title IX procedures. And I think this is a point where if anybody had any questions, we'd be happy to answer them, but we're also going to continue to take questions at the end.
Yeah. We don't have any questions yet in the chat. However, a couple of questions came up for me as you were speaking, Linda. Thank you. You covered a lot of ground in those last couple of slides. And so just going back to the jurisdictional slide, Joy, can you take us back a couple of slides?
Right there.
That one, yes. Would you, either of you, be able to just talk through what would happen if someone were to submit a complaint that fell outside of these jurisdictional requirements, just so that everyone knows how their complaints would be addressed?
So sure, I can give one example and take us through one example. So let's say that someone comes to us with a report of conduct that occurred before August 14th, or conduct that occurred. So for example, a sexual assault or relationship violence or stalking that either occurred before August 14th or occurred at a private residence that was not in no way affiliated with the university, even if there were other university community members present. Then those would not, even if the conduct alleged met the definition of Title IX sexual harassment. So I just said, that the report was of some VAWA offenses that Linda defined. So sexual assault, relationship violence, or stalking. If those, but they would not meet the jurisdictional requirements. So what would happen is that those complaints would go under the procedures for handling other sexual misconduct. So as we said, all sexual misconduct that is problematic, and it will be handled under university policy. And for conduct that doesn't meet the Title IX sexual harassment definition or those jurisdictional requirements, it would go under the procedures for handling other sexual misconduct, which, as I said before, looks very similar to the prior policy, the prior procedures for handling all types of sexual misconduct that existed before August 14th. So there's still, opportunity for informal resolution. There's still opportunity for investigation. There is generally not a hearing, but the OIE recommendations do go to a hearing panel, a decision-making panel. So hopefully that answers the question.
Yeah, and I think it's just important that the audience understand that no matter what, there is a mechanism for addressing the behaviors, even if they don't fit specifically here on this slide. So I just want to reemphasize
Such a
that.
good point.
And then, Linda, you talked a little bit about the hearing process and how there's efforts made to make sure that it's sort of not confrontational and to make sure that it's, I can't say it would be a comfortable environment, but can you talk a little bit about other methodology throughout the process for how we try to ensure safety of the parties who are participating in the process?
Sure. So going back to the slide where that Joy talked about, where we receive a report that comes in, and then we go through the intake, the risk assessment, and supportive measures. That's really when we start speaking to the complainant and to other parties involved to find out what measures may be needed to support them. A common measure that we put in place is mutual no contact orders. So during the OIE process, the parties are directed not to communicate with each other, either directly or through social media or by any means. We can also put in place other measures to ensure that the parties are more comfortable. In addition, it's our practice to connect student parties with their case manager in student affairs. That's somebody who can help them with a variety of different services in terms of getting academic accommodations, connecting with other supportive resources like the counseling center, and also be another person that they can speak to. And in addition, we assign people to a university navigator. And that is someone who is familiar with OIE's process and procedures, as well as with supportive resources. And if a party has a question that they would like to talk to someone about, but they don't feel like speaking to OIE at that time, they can go to the university navigator. They can share as much or as little information as they want with their case manager and navigator. OIE is not going to share with them, but it's another resource for somebody to speak to as they're going through this process, both to get information and to get support. And then we have other, we also connect people with other confidential resources on campus, and we connect them with off-campus resources and provide them information. There's a variety of local resources related to sexual assault, domestic violence, dating violence. So we have a list of all those resources in our policy, and we also will connect people. And finally, if people have safety and security concerns, we regularly facilitate connection with our campus safety and security team. And they're really great at talking to people about safety plans, about getting them security escorts, if that's something that would make them feel more comfortable, and talking to them about other safety issues.
Great, thank you, Linda. It might be helpful as well because you guys have outlined a lot of process, and I know that a lot of this is driven by the new regulations and some of the new things they've had us insert into the process. Can you talk about timing and how long the process takes and the impact that the new regulations have had on the timing?
So sure, I could start out and Linda jump in as well. So, we recognize in OIE that every minute a matter is with us. It is stressful. It's stressful for the parties, for the witnesses. And so we were very cognizant in OIE about the time we take. And we have engaged in a lot of streamlining efforts over the past few years to make sure that we are well staffed and taking as little time as possible on every matter. So I turned us to the Title IX grievance process. Informal resolution, I'm not sure that the new Title IX sexual harassment informal resolution process will take any more time than has previously been taken. Informal resolutions typically are handled by OIE in about 30 to 60 days. What we do anticipate might add some additional time are some of the process additions to the procedures for sexual harassment investigations. So, for example, during the investigation, there's a 10-day period where the parties are able to review the evidence file. And that, while the parties always were able to hear material and relevant evidence and see that in the draft report, this is an additional step in the investigation that has been added per the regulations. So that will add some time to the OIE investigation. We also know that when convening a live hearing and making sure everyone has their hearing advisors and getting witnesses there and everything like that, that could take some additional time as well. So we do think that that investigations under this could take some additional time. Linda, anything else on that?
No, that summed up everything. Yeah.
Yeah, I think it's important to note as well, Joy, you pointed out some of the streamlining measures that have been put into place. And I know that me, as being a new person coming into Hopkins, some of the things that I've noticed that tend to impact the timing are certainly witness availability, both the complainant, the respondent, and witnesses that they both put forward for us to speak to. Those two do tend to drive the process, make it a little lengthier than any of us would like, but we are continuing to input measures to streamline where we can. But those are some of the things that I think impact timing, in addition to what you've just pointed out as well. So,
great.
Jen, what about you? Do you want to jump in and offer a perspective on any of the content that we've covered so far, just from the student affairs perspective?
Sure, yes, thank you, Shannon. I just want to emphasize some points that Linda and Joy both highlighted, in that we work closely with OIE and student affairs. And in addition to taking the panel process once the OIE has completed their investigation and handing it off to student affairs at that point, we also work to make sure that students have ample support throughout the process from beginning to end, and work closely with OIE. So we provide and train supporters. We call them navigators. They're intended to help students navigate the process from beginning to end. They're all very familiar with the process, and particularly the resolution panel process. In fact, a number of them have served as panelists, so they really know the process well and can help students with any process questions and or advice into, not advice, but advice as to what to expect in terms of next steps, and make them, help them anticipate what might come next. We also make sure that students have a case manager support mechanism in place, regardless of what school they're enrolled in. So anywhere from SICE to Krieger to Peabody, we work closely with all the student affairs partners across the institution. Thank you, Shannon.
Thank you. Still no questions in the chat, so we should probably just keep going with the slides.
Great. And one thing, I don't think we've said this so far, but it bears repeating even if we did, that parties are entitled to have a supporter or supporters with them during that process. So they can have one personal supporter, like a friend or a family member, and one supporter who serves as a legal advocate, a lawyer, or some other trained advocate. And they could, that person can come with them to any OIE meeting or proceeding. That person can be involved during the adjudication process. Although the hearing advisor is the person who attends the actual hearing, their supporters can be available to provide support as well outside of the specific hearing. So we want people to know that you do have the opportunity to have people with you, including an attorney if you wish.
And Maryland law actually provides for attorneys for students going through these matters. So the Maryland Higher Education Commission, through the link directly to their website, which is also in our sexual misconduct policy and procedures, provides attorneys at no charge to students who are participating in sexual misconduct matters. So we encourage students to check that out and to use it when needed.
Good point. So the slide in front of you right now is a screenshot of our main website, oie.jhu.edu. We have a ton of information here about all of the policies that OIE oversees. So that includes the discrimination and harassment policy and procedures. It also includes our disability services information, as well as information about religious accommodations. And we also have a tab there for sexual misconduct, and that links to our site that talks specifically about sexual misconduct. So we have a separate site that's sexual misconduct at .jhu.edu. And this is where we have all of our resources and information specifically related to sexual misconduct. So you can see a screenshot here that shows links to various forms of help and support that are available to people both on and off campus. There are also links to be connected with a counselor. There's a link to file an online complaint, and also a link to a 24/7 confidential hotline, which is another resource we have for students. And one important thing that Shannon mentioned earlier is that we have FAQs on this website. We have FAQs both generally about the sexual misconduct policy procedures, and we also have a whole set dedicated to the changes that have been made as a result of the new regulations. So we definitely encourage people to go to this website for more information, for resources, and to get any questions answered. And of course, we're always available to answer them as well.
Great, thanks, Linda. And so we like to also talk in these trainings about responsible employees. So, there are, we like to let everyone know that there are places to go at the university where information will have to be reported to OIE. And then there are confidential resources designated by the university where you can go and talk to a confidential resource and nothing will be reported to the university. A report to a confidential resource does not constitute a report to the university. So responsible employees are designated individuals at the university, and there are a lot of them they're employees of the university who must report everything they learn of regarding sexual misconduct, discrimination, or harassment to OIE. And they must report the names of the individuals who reported it to them and other relevant facts. So we like to remind responsible employees of their duties to report things to us. We also like to remind individuals who are not responsible employees, who might be thinking of talking to someone we'd like them to know about responsible employees. We like to leave people with agency over who they talk to and where that information goes. So we like people to be most informed. If you talk to a responsible employee, so for example, if you're a student, and most students are not responsible employees. The only students who are really responsible employees are RAs. But if you talk to a responsible employee, that information will be forwarded to OIE. There are lots of different categories of responsible employees at the university, and you'll see it's a lot of people. So it's faculty, all faculty are responsible employees, deans, administrators, chairs, human resources and OIE staff, RAs, as I said before, academic advisors, all student affairs staff, athletic coaches, campus safety and security. So there are lots of different, everyone who's a supervisor at the university, who's an employee of the university and supervises others, is also a responsible employee. So there are a lot of people at the university who are responsible employees. If you want, if you want to talk to somebody confidentially, where they will not have to report anything that they learn of to the university or to OIE, there are lots of confidential resources available, especially for students. So we like to make sure that we highlight that. And as I said before, responsible employee duties have been in place for some time. They did not change as we revised the sexual misconduct policy and procedures. So as I said before, if you want to talk to somebody who does not have to report anything to the university, confidential resources are designated. And a full list of confidential resources is located as an appendix to the sexual misconduct policy and procedures. But for students, we've highlighted some here, and we've highlighted them in different categories. So there are, different Homewood and Peabody confidential resources, and then there are others for Bloomberg School of Medicine, East Baltimore campus students, and we encourage you to reach out. The sexual assault helpline that is listed there is for all students, and it's a confidential 24/7 line staffed by trained professionals. who can, who are confidential and can talk through any matters relating to sexual misconduct. We encourage you to contact confidential resources, and again, a full list is in the appendix of the sexual misconduct policy and procedures. So, and we like to end with our contact information. So while OIE is not a confidential resource, we can have lots of different conversations with our community members, and we like to tell people about those different types of conversations that we can have. So, we have a lot of individuals who call us and don't tell us anything. People can engage with OIE. So whenever we get a report, we reach out to the individual. Somebody can engage with us or they cannot engage with us. They can tell us information or they can not tell us information about what's happened. They can get information on policies and procedures from us without telling us any information, and get connected to resources regardless of how much information they share. So we encourage people, OIE is not just for reporting. We're here to also give information to our community members so that everybody is most equipped with information on the policies, procedures, and options and support options they have at JHU. So we encourage you to contact us in a number of different ways to have lots of different conversations. We've even had conversations where someone calls while sitting with a confidential resource. So someone calls from the counseling center, from an appointment, and talks to OIE and asks us questions about the policy and the process. We can have lots of different conversations. We accept anonymous reports. We accept calls, and people have even emailed us without giving us their name. And so we can have those conversations regardless of whether the person identifies himself as well. So, we encourage you to talk directly to OIE as well if you have questions, and certainly if you want to make a report. And you can get in touch with us in a variety of different ways. So our 2 different websites are here, our different email addresses are here, and we are, operational by phone as well. The only thing that has changed during this era of COVID is that we are not currently in our offices. But once this is over, we will be, and in-person walk-ins and in-person meetings will resume. So thank you all very much for the time you've spent with us tonight, and we really appreciate the chance to give more information on this important topic.
Thank you to my panelists. This was a very informative session. I hope everyone got something out of it. And please remember the list of resources that are here. And also, please, if you want to watch the recorded session or direct others to the recorded session, you can come right back to the same webpage and it'll be up. It'll be posted for you. So thank you, everyone.